Hello and welcome everyone to the Polity Primer series of Drishti IAS English. My name is Pragya. In our today's very interesting episode, we are going to talk about another significant constitutional amendment that has recently been struck down by the Honorable Supreme Court of India. So the title of our today's discussion is the 97th Constitutional Amendment Act, which deals with the provisions regarding cooperative societies. So in this discussion, we are firstly going to study about what is the 97th Constitutional Amendment. Then we are also going to analyze its key provisions. Then we are also going to see the Supreme Court ruling in this regard and the implications of this Supreme Court ruling. And lastly, we are going to discuss some of the important questions from the perspective of your prelims examination. So if I talk about the background of our today's topic, recently the Honorable Supreme Court of India, in the case of Union of India versus Rajendra N. Shah, by a 2:1 majority, has held that the Part B that was inserted by the 97th Constitutional Amendment Act is unconstitutional to the extent that it provides for the incorporation of cooperative society and etc. exclusively in the hands of the Parliament. So basically, the fundamental right and the directive principles that were inserted through this amendment were upheld, but Parliament do not have a power over the cooperative society. The power to form or regulate the cooperative society rests completely in the hands of the state government. So it is the exclusive power of the state governments and not of the Union Parliament. Moving forward, let us discuss what was the amendment all about. So basically, as I said, that yes, the 97th Constitutional Amendment dealt about provisions related to the cooperative societies, and it gave constitutional status and protection to the cooperative societies because the United Nations declared that the International Day for Cooperatives. Let me know the date in the comment box below, and after this we provided the constitutional status to the cooperative societies. So before the formation or before this amendment, it was not so that the cooperative societies were not existing in India. In fact, they were existing since pre-independence as well. Okay, so the first Cooperative Societies Act was brought in the year 1904 after it was recommended by the Femine Commission, and through this the very first cooperative society in India, that is the Agriculture Credit Cooperative Society, was formed. So under the Cooperative Societies Act of 1904, this Agricultural Credit Cooperative Society was formed, and this is the very first cooperative society in the pre-independent India. Okay. Cooperation movement became a provincial subject with the Montague-Chelmsford Act of 1919, which boosted the movement's momentum. So yes, the cooperative movements were going on in the India before the pre-independence times as well, and it formed a provincial subject. That means the subject on which the Parliament has the exclusive authority to act during the Montague-Chelmsford reforms of 1919. Moving forward, after independence, cooperatives were envisioned as a balancing force between the public and the private sectors. So when we got independence, we wanted our economy to develop in three major sectors, okay? Public, private and cooperative sector. So basically, this cooperative sector was to act as a balancing force between the public and the private subjects, and they formed even a very huge chunk or very huge part of the 5-year plans, okay, after the country gained independence. Cooperatives together with the panchayat and schools were considered one of the three foundations of the democracy by our first Prime Minister, that is Pandit Jawaharlal Nehru. Moving forward, let us analyze the key provisions that have been inserted in our Indian Constitution through the 97th Constitutional Amendment Act. So basically, it has established the right to establish cooperative societies as a fundamental right under Article 19 clause 1 subclause C. So you have a fundamental right to establish cooperations or unions. And what is a cooperation or a union? See, cooperation is a joint entity that works for a joint purpose. Okay, it works either for a joint social purpose, economic purpose. So basically it has a joint aim to fulfill. And if you talk about the very successful cooperative society in India, Amul is a very famous and successful cooperative society in India. So basically they are working together as an entity to fulfill their social, economic or other such purposes. It featured a new directive principles also on the promotion of cooperative societies under Article 43 clause B2, and both of these have been upheld by the Honorable Supreme Court of India in the judgment of Union of India versus Rajendra and Shah. Then it also created a new part 9B to the Constitution called the Cooperative Societies, and it has added articles 243 clause ZH to 243 clause ZT in our Indian Constitution. So now let us examine one by one what are the constitutional provisions that have been inserted by the 97th Constitutional Amendment Act in our Indian Constitution. So basically the first key change that has been introduced is the incorporation of the cooperative societies. And who has the power to incorporate, regulate and lay down provisions for the winding up of cooperative society? So basically the state legislature. State legislature has the complete power to make any kind of provision for regulation, incorporation and winding up of the cooperative society, and this has been mentioned under Article 243 clause ZI of our Indian Constitution. Then coming to the number and terms of members of board and its office bearers, that is dealt under Article 243 clause ZZ. So the board's composition is determined by again state legislature, but cannot exceed 21 directors in toto. Okay, so this is a restriction that has been placed on the power of the state legislature through this article, and that is why it was challenged before the Honorable Supreme Court of India that effectively the state legislature has the exclusive power. So why are you putting all these kind of restrictions? So elected board members and office bearers serve a 5-year term from the date of their election, and the board elections must be held before the current board's term expires, and the body responsible for conducting these kind of board elections is also determined by the state legislature. Moving forward to the reservation of seats. So yes, the seats are reserved for the SC community, ST community and women. They are entitled to the reservation of seats. Moving forward to the supersession and suspension of board and interim management, that is dealt under Article 243 clause ZL. So basically no cooperative societies board can be superseded or suspended for more than 6 months. For cooperative banks including multi-state cooperative banks, this duration cannot exceed 1 year, and there is an exception that if there is no government and shareholding loan, financial assistance or guarantee, the board cannot be superseded or suspended. So these are some of the restrictions that have been put in the condition of the members of the or the board of the cooperative societies through this amendment. Moving forward, audit of accounts of cooperative society, that is dealt under Article 243 clause ZM. So basically the state legislature may make provisions for the maintenance and auditing of accounts of the cooperative society within 6 months of the close of the financial year at least once in each financial year. So you see, although the state legislature had the power to regulate the cooperative society, but the powers that were given through the part 9B of our Indian Constitution to the state legislature was very restrictive in nature. Okay, and the provisions that are mentioned under these articles of part 9b are also applicable on the multi-state cooperative societies. And cooperative societies in union territory. Societies in UTs as well, until and unless the president by explicit notification excludes the operation of this part in any union territory. So basically they are applicable on the multi-state cooperative societies and the cooperative societies that are functioning in the union territories as well. Moving forward, let us examine the recent Supreme Court ruling and its implications on the Part 9b that was inserted by the 97th Constitutional Amendment Act. So basically, before the Honorable Supreme Court, it was argued that the 97th Amendment Act is against the 7th schedule of the Indian Constitution. How? Because list 2, entry 32 gives the state executive and legislature a complete power to legislate on the subjects that are mentioned in the state list. Okay, so it was against the 7th schedule because it restricted the state executive and the legislative powers with respect to the cooperative society that was a state subject. Okay, you see that the numbers of directors, the audit mechanism, etc., all were well defined under Part 9b that was inserted by the 97th Constitutional Amendment Act. So basically, the parliament through that amendment was trying to restrict the power of the state legislature to make laws on a subject that was exclusively reserved for it under the state list. Then it also violated Article 246 Clause 3 because again it curtailed the legislative powers of the state. Okay. Then it also violated Article 368 Clause 2 because for bringing any kind of amendment in the 7th schedule, you need a special majority of the parliament. Special majority of the parliament. Okay, and it should also be ratified by the 50% of states. So this ratification by the 50% of the states was missing in this constitutional amendment, and that is why it was in clear-cut violation of Article 368 subclause 2. Moving forward, the judgment of the Gujarat High Court that was delivered in the year 2013, in which it said that some of the provisions that were inserted through Part 9b in our Indian Constitution was completely unconstitutional in nature because it was against the spirit of federalism, was upheld by the Honorable Supreme Court except to the extent that it strikes down the entirety of Part 9b of the Constitution of India. So the Gujarat High Court said that the whole Part 9b should be deleted. It was completely and unfairly against the Constitution of India. But the Supreme Court said that no, the fundamental right and the directive principles of state policy is recognized as constitutional. They applied the doctrine of severability. Doctrine of severability. It also said that yes, the Part 9b will be applicable to the multi-state cooperative societies as far as the parliament powers are concerned. But if you talk about the incorporation regulation and the other provisions related to the cooperative society, they fall exclusively in the hands of the state government. Part 9b of the Indian Constitution is operative only insofar as it concerns the multi-state cooperative society, as I have mentioned, both within the various states and in the union territories of India. So this was the judgment of the Honorable Supreme Court in this case. The Supreme Court also applied the doctrine of colorable legislation. It said that the Parliament was trying to amend the Constitution and it did not bring the cooperative society subject in list 2 or list 3. It completely restrained the power of the state government. So what you cannot do directly, you cannot do indirectly, and this is the doctrine of colorable legislation. So whatever the Parliament was not able to do directly, it was trying to do indirectly. It was trying to legislate on the state subject of cooperative societies indirectly by bringing the 97th Constitutional Amendment Act. Moving forward, this means that the Parliament can make laws concerning the regulations of multi-cooperative societies that have operations in more than one state. So on this subject of multi-cooperative society, the Parliament's power to enact laws remains intact. Okay. And changes to Article 19, Clause 1, Subclause C and insertion of Article 43 are not touched and they remained intact. Okay, so these parts were not declared to be unconstitutional. So what was actually declared to be unconstitutional? That the Parliament indirectly had no power to control the cooperative societies whatsoever. So the Part 9b that was inserted by the 97th Constitutional Amendment Act was declared to be unconstitutional to the extent that it allowed the Parliament to restrict the state's right over the state subject. Rest of that was held to be constitutional in nature. You still have a right to form a cooperative society as a fundamental right, and the state is obligated to promote the formation of the cooperative societies by virtue of the directive principles of state policy that has been provided by Article 43 subclause B. So all of these were remained untouched by the Supreme Court. I hope you got the point. You understood what was the amendment, what were the loopholes in the amendment, and what the Honorable Supreme Court has said regarding the amendment. With this, we come to a conclusion of our today's discussion. We have discussed the 97th Constitutional Amendment Act. We have seen the recent developments. We have seen and analyzed the key provisions that were inserted in our Indian Constitution through this amendment, and let us now discuss the previous practice question which I asked in my previous session. So the question is, consider the following statements about the 91st Amendment Act. Your statement number 1 was, the total number of ministers excluding the Prime Minister in the Central Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. Your statement number 2 is, a member of either house of the Parliament belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. Your statement number 3 was, the number of ministers including the chief minister in a state shall not be less than 12. So choose the correct answer from the codes given below. Option A, 1 and 2 only. Option B, 1 only. Option C, 2 and 3 only. And option D is 1, 2 and 3. So definitely your correct answer is going to be option C. Statement 2 and 3 only. And why? Because it includes the Prime Minister. So including the Prime Minister, the Council of Ministers cannot exceed from more than 15% of the total strength in the Lok Sabha. So it is not excluding the Prime Minister, it is rather including the Prime Minister, and that is why statement number 1 is incorrect. Moving forward, let us discuss the practice questions from our today's session. So the first question is, which of the following constitutional amendment acts gave a constitutional status and protection to the cooperative societies? Your options are, option A is 95th Amendment, option B is 96th Amendment, option C is 97th Amendment, and option D is 98th Amendment. So your correct answer definitely is going to be the 97th Constitutional Amendment Act. Moving forward to the next question. The question is, who has the right to make provisions for the incorporation, regulation and winding up of cooperative societies? Option A, Parliament, option B, State Executive, option C, State Legislature, and option D is the cooperative societies themselves. Obviously, the correct answer is going to be option C. The State Legislature is empowered to make provisions regarding the incorporation, regulation and winding up of the cooperative societies. Now, let us discuss the last question of our today's discussion. So the question is, consider the following statements. So statement number 1 is, the Parliament may make provisions for the incorporation and regulation of cooperative societies Your statement number 2 is the maximum number of directors of a cooperative society shall not exceed 25. So, which of these statements given above are correct? Your options are option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above, and this answer will be given by you to me in the comment box below. I would also like to take this opportunity to inform you about our Holi special discount that is going on. So, you have a flat 40% discount on the IAS foundation course, and it will be provided for both English medium and Hindi medium. To avail of the discount, you can click in the link that is given in the description box below, and you can download the Drishti learning app. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.